Hey, hello and welcome to today's webinar. My name is Alicia Fuller. I am an assistant federal defender out in Rapid City. I'm a member of the State Bar CLE committee. Before we get started, I'd like to go over a few items so you know how to participate in today's event. The very first thing we'll cover is something that we cover because of its importance at every CLE. And it's the PSA on lawyers concerned for lawyers and Sand Creek. Do you or a lawyer, judge, or law student you know have a drug or alcohol problem or struggle with depression or anxiety? Lawyers Concerned for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with LCL is strictly confidential and privileged. Call Becky Porter for more information, 605-391-5191. Becky is an LCL member and your communications with her are likewise confidential and privileged. South Dakota State Bar members and their families also have access to the Sand Creek Member Assistance Program, which includes a 24/7 hotline. To reach a trained professional at any hour for a confidential discussion and assessment, please call Sand Creek at 1-888-243-5744. I think staff just did on cue, shared Becky's phone number and the Sand Creek hotline number. So this presentation takes approximately an hour. If you have questions, please submit the text questions to today's presenter by typing your questions into the chat feature on Zoom. You may send in your questions at any time during the presentation. We'll collect and address them during a Q&A session at the end of today's presentation. And we'd like to thank the State Bar of South Dakota and CLE Inc. for their support in today's program. Now let's move on to why we're all here, which is our presenter, Leah Robleski. Can you say it for me?
Robleski,
thank you, is the Executive Director of East River Legal Services. Leah is a 1997 graduate of Creighton Law School. She worked for Legal Aid of Nebraska for 25 years, where she specialized in consumer law, representing low-income consumers in many forums over the years, including state court, bank garnishment proceedings, Chapter 7 bankruptcies, and federal negotiated rulemaking. Her favorite creditors are the U.S. Department of Education and the IRS. And with that, we'll turn it over to Leah for her presentation. So thank you.
Great, thank you. This is absolutely my favorite topic. And when I went to law school, I had no idea that my career was going to take me in this direction. I started doing consumer law as a young legal aid attorney and found it really fulfilling. The law is very clear in this area, and it was a place where I was able to be successful for my clients. What surprised me is that I knew that I wanted to work with low-income populations and legal issues, but it had never occurred to me that bankruptcy would be such an incredible need with low-income consumers. And over the years, I've recognized that low-income consumers really have the same legal issues as middle or higher income consumers, but there's sometimes a different remedy or a different way of looking at the situation. So what I've done with my presentation today is take some really common consumer issues and have put them, looking at them through the lens of representing low-income clients. And I'll put in some context as to why I think this should matter, even if you're not working for a legal aid program. So from the introduction, as you learned, I'm new to South Dakota. I've just been here 6 months, but I am not new to representing low-income consumers. This has been what I've been doing for the last 25 years. When I came to East River Legal Services, I learned that this is not a practice area at the civil legal aid programs in South Dakota. And there really isn't a lot in the way of pro se or pro bono assistance for clients in this area. It's an area that I'm very interested in, and I think it makes a huge impact on people. We've been getting an increase in requests for help in consumer areas at East River, and I think part of that is due to the end of a lot of assistance that low-income people were receiving during the pandemic, for example, and some collection activities have just really amped up. There is, as I said, a lack of resources in this area, and I do think that that consumer law is a poverty issue and is pretty unique for a couple of reasons. One, and I think if you have a longer career, you may have noticed that courts are being used differently now than they were in previous generations. So for example, the number of evictions, the number of family law cases, the number of collection cases have all increased. And a lot of that has to do with corporations, for example, figuring out that they can use the courts to collect debts, and that there are statutorily some ways that they can collect debts that they may not have been able to collect from in other ways. So I affectionately refer to my clients as turnips. You've probably heard the phrase, you can't get blood from a turnip. But it's amazing to me how often creditors are able to get low-income people to prioritize debts that they probably should not be prioritizing or may negatively impact themselves, their family, or even their community. My concern is that the court system is set up with rules and processes that are designed for lawyers. And so if you have an individual in a civil case, they don't have a lot of options if they can't afford an attorney. They have been involuntarily brought into the court system without being able to afford an attorney, and they're being held to all of the rules and restrictions that have been put in place with the idea that there's an attorney on both sides. So I think in consumer law, in an area where 98% of defendants are unrepresented and default judgments happen regularly, and there are protections available to prevent further collection, this is an area of the law that can have a dramatic impact on low-income families. And I think that that's something that should be important to all of us. So some common debt issues that I'm going to go through and kind of highlight some differences between a low-income debtor and a middle or higher income debtor. And I just listed them out here. We're going to go through all of these individually and talk about some of the differences when your debtor is of lower income. And just to share a statistic, about 12% of households in South Dakota are at poverty level. East River Legal Services and a lot of other social service agencies operate on a higher increase than that. So for example, we have clients who are at 125% of poverty level. Most of our clients are working. They're just working in a low-paying service industry job. So they are employed, and their wages in particular are eligible for garnishment, and they need all of those wages to cover their monthly bills. So that's the type of consumer that we're talking about. So a low-income client who has secured debt may have a non-purchase money security interest. These are actually really common for low-income consumers. When I took secured transactions in law school, I just could not imagine how any of that would have anything to do with my law practice, but I will tell you that this comes up a lot. So a non-purchase money security interest for a low-income debtor may look like a title loan for a car, which are not legal in this state, but they are legal in other states. So your client may have one from another state. It may be from, I have this in rural communities a lot, a low-income client may have really bad credit and they need to get a loan, and the local bank may have a relationship with that debtor and agree to make a loan, but take a collateral interest in some personal property that the debtor already owns. So I just have found it's really important to, when you're asking about loans, asking whether anyone has an interest in any of their property. And the client may not realize that that's what the loan agreement said at the local bank, but they may have given them a security interest in their household goods, for example, or in a vehicle that they thought was already paid off. So it's important to identify whether that's a purchase money security agreement or a non-purchase money security agreement. Using those terms with a low-income client is not going to mean much to them, but asking them about the loan and reviewing loan documents is really important, I have found. A low-income consumer is likely to be upside down on their car loan, so they probably owe more than the car is worth, and that's due to a lot of reasons. Sometimes they may have had bad credit, so they have a bad credit score. There may be other unfavorable loan terms that have late fees, or the way the fees are calculated may have led to a much higher balance than the actual value of the car. There may have been an accident with some damage that wasn't covered by insurance, and so there was an amount owed on a previous loan that was rolled over into this loan. Those are all really common with a low-income consumer. There are some options available to low-income consumers in both of these instances when filing bankruptcy, for example. So dealing with an upside-down car loan, dealing with a non-purchase money security agreement may have some favorable outcomes in a bankruptcy, and that's why those issues are so important. A low-income individual may have a house that's in need of repairs. So if they have had a really tight budget, they haven't been able to cover their monthly expenses or have been barely covering their monthly expenses, they probably have not been able to maintain their home in the way it should have been. So there may be damage to it, or the value itself may be impacted. The problem, of course, with the home values right now is that you may have a client that looks like they have a lot of equity in their home, but there may be issues with the property. So it may need repairs, and that may be why the client's not able to get a home equity loan in addition to probably their credit. There may also be title issues. I have found these a lot in low-income families because the family is not able to prioritize getting legal assistance when they need it. For example, if someone died and it's unclear that the title transferred, or if there's a divorce, or if there's a relationship that has broken up, but there was not a marriage or a divorce, those all may impact the title of the client's real estate, and they may not have been able to resolve that issue when the legal issue came up. So if they are in some type of a financial crisis at this time, it may be further complicated by the fact that their ex-husband is still on the title and the loan to the house, for example. Low-income debtor is likely to have co-debtors, and that primarily has to do with poor credit. So if they are not able to get a car loan, they may have, for example, asked their grandmother to co-sign the car loan, and then that needs to be part of the decision about what to do with the debt. And unfortunately, when you have even poor financial decisions that are connected to property or lifestyle, that is a very emotional decision for a client to make a decision to let go of a house, even if they know they can't afford it, or to let go of a car, even though that they know that they can't afford it. So there's particularly when I have found my clients work extremely hard, honestly harder than I've ever worked. And so it's difficult for them to understand that they may be working very hard, but they're not able to afford the things that they want to afford. Just a moment. The good news is that there's some very interesting options, particularly in bankruptcy, for low-income debtors dealing with, as I said, some of these issues. And of course, there are special considerations for co-debtors in a bankruptcy because it may discharge the debt for the person filing bankruptcy, but not the person who has co-signed the loan. I actually see a lot of credit card debt in my low-income clients. The balance is usually around $1,000. And it generally started, I don't know how credit card companies figured this out, but the magic number seems to be a $300 balance limit or credit limit, and which the client then runs up because they're low, they don't have enough money in their budget, or they had an emergency or whatever. They quickly will max out the credit card, which then comes with interest and fees. And by the time it's turned over to a collection agency, it's $1,000. And that's generally about the amount that individuals are sued for at this level. These types of credit cards tend to be sold to debt collectors. And what we are noticing at East River is that these are being collected by out-of-state debt attorneys. So for the most part, these debt attorneys are in Minnesota or Wisconsin. They're filing lawsuits against consumers in the state of South Dakota, filing wage garnishments, even personal property executions in South Dakota, but they're not traveling to South Dakota. One of the reasons they don't have to do that is that, as I said, 98% of these cases, the defendant is pro se. They don't file an answer. They really admit that they owe the money. They just don't know what to do. And really, it comes down to the fact that they can't afford to pay the debt. So the process is that these collection cases for credit card debt in particular are being filed by out-of-state debt collection agencies and then collected against low-income consumers, as I said, primarily through bank and wage garnishment. That's what we're seeing at East River. Debtors can file a pro se answer to dispute the debt if they're sued with a lawsuit and find out the origin of the debt. But the result of that is then going to be further confusion for the client. So generally they'll be served with discovery. It's not as if there's going to be an easy resolution in these situations. In most of these cases, there's not a defense. The defendant or debtor knows that they owe the money. They just can't afford to pay it. And this type of debt is dischargeable in a bankruptcy, even if there's a judgment. And that's a myth that I have to dispel a lot. Unfortunately, sometimes people think if they've been sued or there's a judgment, that debt is not dischargeable in a bankruptcy, but it would be. Medical debt is often due to co-payments and deductibles. There's also medical debt that's due to being uninsured. It's honestly less common. It's mostly co-payments or deductibles. Hospital debt is often available through the hospital. If asked for at the patient account system, patients should receive information about their ability to apply for medical debt forgiveness or whatever the program is called at that particular hospital. It's important to keep in mind that that forgiveness program is probably through the hospital, and there's multiple medical providers. So you may get a bill from the hospital, which could be forgiven, but there's also probably a bill from the Physicians Association, also from the lab tech or whatever work was done that may not be billed through the hospital. It might be billed separately. And so it's important to follow up with each of those medical providers to see if there is any type of forgiveness or anything that can be done for that bill. This is often a case where there's not likely a defense. The patient admits that they received the medical service, they just can't afford to pay for it, and it is dischargeable in a bankruptcy. There is some litigation that can be done in this area about medical necessity and the rates being charged by the hospital and all those sorts of things. And for the most part, I'm not talking about special circumstances or FDCPA claims or Affordable Care Act claims about hospital bills. This is just meant to be a very basic seminar to help you issue spot issues that are common to low-income consumers. Student loans come up a lot with low-income clients. And most of my clients have at one point tried to attend school to improve their situation. Unfortunately, they're not very successful. Generally, they don't finish their program, or the school closes, or some sort of unfortunate thing happens. It's really common for a low-income individual to have student loans from a semester or a couple of years of trying to go to school. The Department of Education can garnish wages without a court order, which makes it they do send you a notice, but I can promise you at that point, the client's probably not opening their mail. So if you have a client who tells you that they're being garnished for their student loans, they probably are. And there's probably something that can be done to stop it. This is why the Department of Ed is one of my favorite creditors. They usually don't go away. They are going away more than they used to, but it used to be that student loans were with you until you died. For a lot of low-income people, that's still the circumstance because they did not finish their program. They are ineligible for things like public service discharge because they may be working at Walmart or something like that. So, but that doesn't mean that there aren't other options for either repayment or discharge. This is one of those creditors that you can reach out to at any time. So unlike a medical bill or a credit card that has already gone to court where there's been a judgment entered, student loans in the Department of Education are pretty flexible. So even if the loan has defaulted, even if the client is being garnished, if they reach out to the Department of Education, there will be an option to rehabilitate their student loan. It's going to look different in a lot of circumstances. It may require a monthly payment for a certain amount of time. But for the most part, even if they just share their financial situation, the Department of Education will rehabilitate the loan and let them get into an affordable repayment plan. Another option for low-income consumers is filing bankruptcy. And I know that most people think student loans are not dischargeable in a bankruptcy. That is not my experience. I've litigated student loan cases in bankruptcy court with success, and my clients tend to be people who are working but are not earning enough to ever pay their student loans off. And if you can show that to the bankruptcy court judge, including their income, their expenses, the financial history of that client, and the problems that they have had with repayment over the years, in my experience, you can be successful. I've certainly heard that that's not the case here in South Dakota. I would welcome the opportunity to present a case in this area. I think that if, as a practicing bankruptcy attorney, if you would be interested in going into this area, I would be more than happy to consult and talk with you about these cases. It can make a huge difference to a client who has a high debt load due to their student loans, and being able to relieve that debt load is possible through the bankruptcy code. It takes a finding that it would cause undue hardship to repay the student loan, which again can be shown through the testimony of the client about their income and their expenses and the chance that their financial situation is going to improve or get worse. There are other options also for discharge. Public service student loan forgiveness is has gotten a lot of attention lately. And you can also apply for discharge due to disability. So if a lender or debtor isn't able to work to repay their student loans, they can request a disability discharge. There's other discharges as well for closed schools, or if someone should not have been allowed to enroll in the program. As I said, the Department of Education is very reasonable. So if you call and talk to them, there's probably an option for the client situation. Taxes are another situation where honestly, it's never too late. You can always contact the IRS. They also are pretty aggressive because they can be. Really, they just have to send you a letter. They need to send you a notice to tell you that they're going to be levying your wages or putting a lien on your property, which you can object to. And again, if you contact them, you can usually work something out with them. They're very reasonable. And one of the things I like about both the IRS and Department of Education is that they actually look at the client's ability to pay. So they're one of the few creditors where to respond with, yes, we know we owe this, but we can't pay it, is a legitimate response. Both the Department of Education and IRS will work out a repayment option or help people get out of default. They really just need people to be accountable and communicate. The best place to start with taxes is to order a tax transcript, which you can do on the IRS website. And for low-income taxpayers, which is pretty generous, I'm trying to, I think it's much more than 125%. It's, I mean, I know, I think a family of 3 can earn $60,000. I just referred someone to them recently. So it's pretty generous with its income guidelines, but there is assistance available. It's through the IRS, but it is for advocates for taxpayers. The other option for tax debt may be to file bankruptcy. And that's why the tax transcript is so important, because it will actually show you when the tax was owed, when the client filed the return, or if the IRS had to file the return because the client did not file the return. So bankruptcy may be an option depending on the type of debt and the length of time. So again, I think that's a common misperception that taxes are not dischargeable. They may be dischargeable, particularly for a low-income debtor in a Chapter 7. So if you have the information from your tax transcript, you can get better advice from a bankruptcy attorney about whether that debt would be dischargeable. Landlord-tenant debt is something that shows up for low-income debtors. It's less likely for a higher-income debtor. Usually this is from a judgment owed after a lawsuit filed by the landlord. It's usually a default judgment. And my suggestion for this debt is to file bankruptcy, depending on the situation. But there's not a lot you can do, obviously, to go back and relitigate the amount that's owed. A default landlord-tenant judgment is likely to be much more than the tenant thinks is owed, but without somehow vacating the judgment and relitigating the case, your client is going to be stuck with that judgment amount, and the replacement of the carpet or repainting the apartment or whatever the landlord was able to obtain a judgment for. So common solutions for that lawyers present to clients when they come in include usually discussing the bankruptcy option, discussing litigation or settlement, and then the classic legal aid answer, do nothing. So we'll go through each of those. So bankruptcy options that are available for lower income debtors include the ability to recover wage garnishment due to a special portion of the bankruptcy code concerning preferential payments. And so oddly, because wage garnishments are not voluntary, those are involuntary payments. And if you can show that the involuntary payments in the 90 days before you filed bankruptcy meant that the creditor garnishing you got more money than your other creditors, then ironically, the debtor can get that money back if they can exempt it as personal property. So that's a lot of bankruptcy lingo, but it's pretty much magic for your client if you can help them file bankruptcy, stop the wage garnishment, and then you give them a check for a couple $1,000s for the wages that have been taken. So that's something that's generally available for low-income debtors if they're being garnished. Another option would be to release liens or rewrite the loan terms, which was what I was talking about with regard to the secured debt. So in a bankruptcy, even if you have filed a Chapter 7, there are a couple of options for secured loans, particularly car loans, that would allow the client to, for example, rewrite the loan to owe the value of the car and discharge the remaining amount. And they would need to redeem the loan or do something like that. But there are some options through bankruptcy that can make loan terms a lot more favorable for clients and more. Another benefit for low-income debtors is, as I said, discharging student loan debt, also tax debt. Bankruptcy is pretty affordable through private attorneys. It's one of those practices where for a simple bankruptcy, most bankruptcy firms are going to have a process that you go through that's pretty streamlined. It just takes a couple of months if you have the money up front. One good thing about bankruptcy, it is complicated. There's lots of different sections of the code that interrelate to each other, but there are free options. So if a client can't afford an attorney, there are a couple of free services. Upsolve is one. They're actually online and the client just works directly with the Upsolve platform. Those schedules are reviewed by an attorney before they're filed. And then there's NOLO, which is usually at the public libraries, and I hope you're all familiar with those, but they are pro se materials in different legal areas, and there's a specific NOLO manual for bankruptcy. There's also a tab on our local bankruptcy court website, and I'll share that later here in the presentation. Pro se bankruptcy is not, I would say, I think people are always better off being represented by an attorney, and I think you're going to get the best outcome because attorneys are going to identify the different ways your issues can be resolved in bankruptcy. But there is a shortage not only of attorneys, but of bankruptcy attorneys in South Dakota. So unfortunately, this is just one of the options that we have to present to people. And it does work better with support. So that's one of the reasons that I like Upsolve. And you can also request to have the filing fee waived if you are doing a pro bono bankruptcy, or if the client's using Upsolve or filing on their own, they can request to have the fee waived. The best part about bankruptcy is stopping a wage garnishment. That's usually why low-income consumers file bankruptcy. I can tell you that there are states that don't have wage garnishment. So Texas, for example, doesn't allow wage garnishment, and bankruptcy filings among low-income consumers is significantly lower than in states like other states that allow wage garnishment. A wage garnishment, as you can imagine, if you're at poverty or just above poverty and your wages are suddenly being garnished at 20%, you were having a hard time paying your electric bill last month, you're not going to be able to pay it this month. So stopping that wage garnishment is really essential to a low-income household because otherwise they're not able to pay their bills. So this is where most lawyers help clients resolve consumer issues. This is what we're used to for a middle income client or higher income client, that you would just reach out to opposing counsel or reach out to the company and try and work out some type of a settlement and a payment. I can tell you that when a legal aid client contacts, they often say, I've tried to make a payment and I want to make a payment. How can I make a payment arrangement? And I always have to back them off because I just feel like we're not ready to start with offering to make a payment until I know what your budget is, because we need to make sure that that payment is realistic. I've had clients that were making payments on a bank loan and not buying their medication because there was one or the other. So sometimes people make decisions that they think are the right decisions when they're adversely affecting themselves. And I think that determining your budget before you determine your payments is just essential. Low-income budgets are a little special, and I'm going to talk about those in a little bit. So it's going to be different than a middle-income family's budget. One thing that the creditor is thinking about when you're making a payment is how much they can garnish you for. And in my experience, creditors, if they have the option of wage garnishment, are not going to be really excited about taking a payment that's less than that's voluntary, that they may or may not get. So that's something to keep in consideration. Also remember, if the individual is pro se, they are using a system that's designed for lawyers. So they don't feel empowered. They don't understand what's going on. Court rarely meets people's expectations. I'm sure you've all had clients that are just sure if they could just go to court and explain their situation to the judge would understand, where they're coming from. And so managing expectations that the judge doesn't need to hear about your health problems, doesn't need to hear about the divorce, doesn't need to, all the judge cares about is whether you owe this credit card bill. And then the next question is whether you can pay it. And that's really a much simpler answer than most clients understand. So most clients want to go into a lot of detail. This is a very emotional and embarrassing situation for them. And as I think you all know, the court really doesn't care. They are just there to determine whether someone owes money and whether they should be court ordered or forced to pay it. And so helping clients understand the purpose of court and that filing an answer against this out-of-state collection company is not going to be an easy or satisfying process. It's certainly something that they're entitled to go through, but I think for a low-income pro se person, litigation is not the best route. Oops. So for a low-income legal aid client, my advice, and this is a really hard thing for a lot of people to accept, is to do nothing. So I'm not talking about a client who has assets that are not exempt. I'm not talking about someone who, is working a full-time job and whose wages could be garnished. I'm talking about maybe someone who's disabled or retired or who works 20 hours a week instead of 40 hours a week. And so if you have determined that the debtor doesn't have any assets that a creditor that the court could take from them, that their liabilities are managed, that they're communicating with their creditors, and just their general living situation. So we know that this person might go back to work next month. They're not working right now. So at least for now, they may not need to do anything. Instead of advising clients about what bills to pay, I call it prioritizing debt. And I've really found that works better than saying, don't pay the bank loan. Instead, I say, okay, let's pay for your prescriptions. Let's pay your rent. Let's pay your utilities. How much do you need for gas? How much do you need for, an oil change this month? And then how much is left over after that? So it's really not about cutting creditors out. It's not trying to get out of responsibility. It's about prioritizing your responsibility and prioritizing your debts. Debtors in this situation where the best advice is to do nothing really need a lot of ongoing support. Here at East River, we have senior clients that call pretty regularly. So these are individuals whose only income is Social Security. They don't have any assets that can be taken from them, and they're really stressed out by creditors. And so we have told them, you can call us, we will talk you through whatever notice you've gotten and make sure that our advice is the same. But in that situation, our advice might be, you don't need to do anything. Just a quick word on exemptions. So exemptions are the laws that protect the property that you own. So this is what creditors cannot take from you. South Dakota has pretty low exemptions by a lot of standards, but they fit most low-income consumers. So you'll find that their assets will fit pretty comfortably in these categories. So there's real estate and household goods, which are protected by state law. Retirement accounts, both state and federal law. South Dakota does not have a protection for an exemption for a vehicle or for a bank account. So both of those things are going to have to fall under what's called a wild card. I actually have a picture slide for this that I left out. It's a Bloody Mary with all the skewers with all the different foods on them. One of those really crazy ones that has like a little piece of pizza and a cheese stick and a little mini hot dog, and also celery, also olives, also cherry tomatoes. So basically with the wild card, you're like shoving all the weird stuff on a skewer and trying to get it to stick. There are a couple of pieces of property that are very important to low-income debtors. It's not going back. So Social Security benefits, just a minute, are protected by federal law. Earned income tax credit is protected by federal law, and also student loans or grants. These are all funds that are commonly in bank accounts for low-income individuals. And these bank accounts can be garnished by creditors that have a judgment. It's important that debtors or consumers know that they can request that those funds be released or returned to them, depending on where they're at in the collection process. The problem is that the burden is on the consumer or the debtor to raise that claim. So the problems with the exemption process are that there is not a pro se form to request a claim of exemptions. And again, in my opinion, this is an inequitable process. So the rule of law is not designed for a pro se debtor to raise this claim. So they have, this is a valid legal claim that they have. The statute is there that protects their bank account, but they're not able to access that protection. And so in my opinion, that's problematic and something that we're trying to address. So there are resources available for low-income consumers. Both East River and Dakota Plains Legal Services are offering limited advice and information in these types of cases. We have a couple of pro se forms available when clients call, and we're able to talk to them about the pro se process and representing themselves in court. So at this time, that's the only way we're able to help low-income consumers at legal aid. I would encourage you as a private attorney to consider pro bono and volunteer to take a consumer case. These are really satisfying cases. So unlike me calling you and begging you to take a contested divorce case that's going to last 3 years, consider taking a consumer case that could take, just a couple of weeks, or maybe a senior citizen that you would be willing to talk to on the phone whenever they get a confusing court notice or something like that. Other options would be to file a complaint with the Attorney General. They particularly do a great job investigating fraud. So if you have a client who has been the victim of fraud, there are ways to report that through the Attorney General website, and they can investigate that and possibly help. And then, of course, pro se materials are available through both NOLO and Upsolve. Some free resources, just so that you're all aware. The Consumer Financial Protection Bureau has some really good budgeting tools. And what I like about them is that they are designed for low-income consumers. So for example, there is a line in the budget to put in the amount that you receive for food stamps. There's a lot you can, if you have irregular income, which is pretty common for a low-income person in the service industry, there's a budget tool for a person with irregular income. There's also just information about how to take out a car loan or what to look for in a loan document. The Federal Trade Commission is my favorite resource for identity theft. So there is a tool available on the FTC website where you can report identity theft, and then they actually create a list of next steps for you that include contacts. So for example, if I were to file for identity theft with the FTC and identified that I thought my taxes had been intercepted, they would give me information about how to report that specifically to the IRS as well. Another great free resource is annualcreditreport.com. So I think it confuses people that it's .com and not .org. But this is a free credit report, and you can get one from each of the 3 credit reporting agencies and file disputes with them through this website. And it's, in my opinion, more accurate and more helpful than creditkarma.com, which advertises on TV, which is, I think, why everyone uses it. But the annual credit report is your actual credit report, and it includes the dispute feature, which is what your clients may need if they're going to be disputing the things on their report. IRS.gov and ED.gov, again, just to find out what you owe and to resolve it. And then the link for the South Dakota Bankruptcy Court. And as I said, they have a whole tab just for pro se self-help litigants in bankruptcy. So I appreciate everyone sitting through this. I know listening to consumer issues for low-income citizens is may not seem relevant to your practice, but I do think that it's important for all of us to recognize that our courts are being used differently than they used to be used. And in the United States, you can be sued by a credit card company, you can be sued by a landlord, you can be sued by your ex-husband, and you don't have a right to an attorney in any of those cases. So in these instances, people are floundering as they try and utilize or exercise their rights. They have the right to claim an exemption. The problem is they're having difficulty getting into court to do that. So I think it's important to recognize that there's a process, but that clients are having difficulty accessing the process. So in my opinion, this has impacted the functionality of the rule of law. We have a very aggressive debt collectors that are negatively impacting communities. Another of my concerns is that, as I said, if someone in a town in South Dakota is having their wages garnished by an out-of-state debt collector, that South Dakota citizen is going to have difficulty paying their rent to their landlord. They're going to have difficulty buying food for their family. They're going to have difficulty paying their car loan to the local bank, difficulty getting people to work and school if the car gets repossessed, and everything just it's in a spiral. So I think that we need to recognize that debt collection negatively impacts communities because it impacts their ability to care for their families and to go to work and to take care of local obligations as well. So I think that the impact on the communities needs to be considered. So I hope that I've inspired you a bit to care a bit more about this topic that is honestly just a passion of mine. I would encourage you to partner or volunteer to help East River expand to this area of practice. And I also hope that you now understand the limitation of our resources so that you can make good referrals. So if you have, for example, if you do defense work and you have a criminal defendant with a consumer issue, please feel free to refer them to East River Legal Services. Just help the client have realistic expectations about what we're able to do. And please feel free to share any of the resources that are intended for low-income pro se consumers. We would appreciate you getting the word out on that. So that's all I had. I would welcome any questions. It looks like we have a couple in the chat.
This is Alicia. I don't see any questions in the chat just yet, but your final comment, I do only criminal defense. I was at the public defender's office in Pennington County for almost a decade, and now I'm at the feds. I didn't hear, and if you said it, I apologize. What about criminal fines, court costs, and then restitution is a separate thing? And then with that, we have a lot of low-income clients that they're not paying, so it goes to collections, which can then negatively impact whether they can get a driver's license and all of those things. So is there help there for that? And is it dischargeable? All of a huge question.
Yeah, no, I appreciate that. That is a huge topic that is being discussed nationwide. And these criminal fines and fees often, either keep people in jail or send them back to jail, or at the very least impact their credit. So I honestly am not familiar enough with South Dakota at this point to comment on that, but that's something I'm interested in looking into more. I know, and as far as a bankruptcy discharge goes, it really depends on the language of the order, and there are exceptions to discharge also that may impact whether the fines and fees are discharged, but in some instances they can be. I know in Nebraska, we were filing separate requests with the criminal court showing undue hardship for the defendant and asking the judge to waive the fees. That had to do with a special section of the statute in Nebraska. We were not having a lot of success with that, even though it was included in the statute. I think a lot of judges were just really pushing back on that idea. But I'm not familiar. I don't think anything's being done in South Dakota on that topic, but it's something I'm interested in looking into. Does anyone else know if there's anything that can be done with criminal fines and fees in South Dakota? Is there a process to request that the court waive them?
Yeah, I think at any point a defendant can ask that the fines or the court costs or something be hardshiped. But
Mhm.
often what happens is it gets ordered and then the person never is engaged back with, they're not where they're supposed to be, so they don't get the collections letter, they don't make the payment, and then by then it's kind of too late.
Yeah.
But I guess it's advocacy on the part of the criminal defense attorney to try to get it zeroed out at the start.
We'll just
But
add that to your list of stuff you're supposed to do when you're doing criminal defense, is that you have to do that.
understood. Understood. But is there any, and I believe restitution in essence gets converted somewhat to a civil judgment. So if that's the case, does it just kind of fall into line with what you covered? Like,
So usually the restitution order language is going to control whether it's dischargeable in a bankruptcy, in my experience. Again, I have not had this issue in South Dakota yet. I have not researched it.
okay. And I don't want to hijack all the questions. If anybody else, I obviously have my own little niche that I'm interested in, but this was all very interesting for me to kind of get that bird's eye view, so I at least can get clients that maybe have these issues pointed in the right direction that's away from me. But um, does anybody else have any other questions? I don't see any in the chat. If so, I guess just unmute yourself and let's be heard if you don't want to put it in the chat. All right, well, I am not seeing anything. So Lee, I really want to thank you for presenting on this topic. It is very interesting. And I think your PowerPoint and your information on resources is, I think, very helpful
Good.
for all of us. So for those of you in attendance, if anyone has any additional questions, please contact the state bar at info@southdakotabar.net and we'll get them directed to Leah. And once you leave today's webinar, you will receive a survey on the presentation, and we would appreciate it if you would complete and provide your feedback. It is helpful. As a member of the CLE committee, we do look for what the membership is seeing and what they'd like to see and what they appreciate, so we can repeat. So please fill out that survey. And unless anybody else jumps in with a question, and on behalf of the State Bar of South Dakota, I'd like to thank everybody for joining us and especially thank Leah for presenting, and everybody have a great day.